So, World War II is over. The confetti has settled, the parades have marched, and Europe is a smoking crater. The Allies have a rather unique administrative problem: what to do with the senior leadership of a regime that turned genocide into an industrialized, bureaucratic process. Before 1945, there wasn't exactly a legal playbook for this. You couldn't just fine them for a noise complaint. The solution was the Nuremberg Trials, an attempt to apply the cold, sober logic of law to the absolute madness of the previous decade. It was a noble idea, except for one tiny, insignificant detail. Much of the law they used had to be invented on the spot. It's like writing the rules to a game after the final whistle has blown, and then announcing the losing team is also being charged with crimes against sportsmanship, a term you just came up with. The main charge leveled against the defendants was crimes against peace, essentially waging a war of aggression. A fantastic concept, morally sound. The only problem was, it wasn't really a crime in international law when they did it. This is called ex post facto law, punishing someone for an act that wasn't illegal at the time it was committed. It's generally considered a major legal no-no. Prosecutors scrambled and pointed to the 1928 Kellogg-Briand Pact, an international agreement where countries pinky promised not to use war to resolve disputes. A pact that had been violated by pretty much everyone who signed it, including some of the nations now sitting in judgment. It was the legal equivalent of citing an expired coupon as proof of purchase. Speaking of the judges, let's talk about the seating arrangement. You had judges from the US, Britain, and France, which makes sense. And then you had a judge from the Soviet Union. Yes, that Soviet Union, the one that had signed a non-aggression pact with Germany in 1939 and jointly carved up Poland. The Soviet prosecutor even tried to blame the Katyn Forest massacre, where the Soviets themselves had executed 22,000 Polish officers, on the Germans. This led to some spectacularly awkward moments in the courtroom. It's hard to maintain the moral high ground when one of your chief prosecutors is from a regime that had been practicing for the totalitarianism Olympics for decades. The hypocrisy was so thick you could cut it with a sickle. One of the most enduring legacies of Nuremberg was the absolute demolition of the superior orders defense. For centuries, soldiers and officials had a pretty simple out: I was just following orders. The court at Nuremberg looked at this argument, considered the mountains of evidence detailing systematic slaughter, and collectively said, no, not good enough. They established a new, deeply uncomfortable principle that an individual has a moral and legal duty to disobey a manifestly illegal order. Figures like Field Marshal Wilhelm Keitel, who basically argued his job was to say "yes, sir" efficiently, found this out the hard way. Suddenly, personal responsibility was a thing, much to the horror of bureaucrats everywhere. The selection process for who sat in the dock was also a masterpiece of political convenience. Why were some industrialists who armed the German state prosecuted, while others who did the exact same thing walked free? Alfred Krupp was convicted, but his American and British business partners who had helped Germany rearm in the 1930s were, of course, not on trial. The Allies also decided not to prosecute anyone for the terror bombing of cities like Dresden, because that would have meant putting their own air marshals in the dock right next to the German high command. This wasn't just justice, it was victors' justice, and the victors got to decide where the spotlight of accountability would shine, and, more importantly, where it wouldn't. At the heart of this legal storm was the chief U.S. prosecutor, Robert H. Jackson. He was a sitting Supreme Court justice, and he knew perfectly well that the whole endeavor was built on shaky legal ground. He wasn't trying to just punish the guilty, he was trying to build a new foundation for international law using the rubble of the old world. Jackson famously stated in his opening argument, "We must never forget that the record on which we judge these defendants is the record on which history will judge us tomorrow." He understood the risks. He knew that if they messed this up, it wouldn't be seen as a triumph of law, but as a high-minded lynching. A noble gamble, but a gamble nonetheless. In the end, the verdicts came down. 12 were sentenced to hang, others got long prison sentences, and a surprising 3 were acquitted. The trials successfully documented the horrors of the regime in excruciating detail, creating an undeniable historical record. It forced humanity to look in the mirror. But did it stop future genocides? Cambodia, Rwanda, Bosnia? The 20th century's second half suggests the answer is a resounding no. The principles of Nuremberg created a beautiful ideal for international law, but it's an ideal that has been consistently and conveniently ignored by powerful nations whenever it suits them. It gave us the language to condemn war crimes while doing very little to actually stop them. So, was it all a pointless exercise in hypocrisy? A show trial? Not exactly. For all its flaws, for all its legal gymnastics and political compromises, Nuremberg did something revolutionary. It established that a head of state could be held criminally responsible for their actions. It declared that "I was just doing my job" is not a defense for participating in mass murder. It was a messy, imperfect, and deeply controversial first draft of global justice. The world is still arguing about the edits. It didn't create a perfect world, but it did create a precedent that makes tyrants just a little more nervous. And for that, maybe the legal awkwardness was worth it. If you enjoyed this video, please like, comment, and subscribe to our channel for more historical insights. Thanks for watching, nerds!